Hello, everybody.
Go hard here this morning along with Mr. Olafson, so we can proceed with arraignment and prosecutors here as well.
Okay, great. We'll go ahead and call the Chad Olafson matter.
Morning, Judge. Bo Harlan appearing on behalf of Chad Olafson, and there's actually two matters: the infraction I filed also appearance on, but most importantly is the DUI. That's case number 5A04528084. We will waive a reading of any citation or charging document under plea of not guilty and ask for dates in ordinary course.
All right, thank you. Sir, can you please state your full name?
Chad Fergus Olafson.
Thank you, sir. And what's your birthday?
10/1/1976.
Thank you, sir. You're here for your arraignment on one count of driving while under the influence. That's a gross misdemeanor, carries maximum penalties of 364 days in jail and a $5,000 fine. Not necessarily what you would be sentenced to, sir, just the maximums you could be sentenced up to. Your attorney has indicated that you're going to enter a not guilty plea today. All that does is all that does is preserve all of your rights. We're going to waive the formal reading. Your not guilty plea will be accepted. I did review this case prior to this morning, and I did find there is probable cause. I'll hear from the prosecutor on recommendation for release. Ms. Carmi?
Yes, Your Honor, we are asking for beyond standard release. I think there is a mandatory component here that we at least have to have. There is a 2012 prior DUI that he pled guilty to. This is a blood draw case, so obviously we don't have the benefit of knowing what the BAC level is. Often if it's a lower BAC and there's a prior, I'll recommend ignition interlock or random UAs. If it's higher, I'll typically recommend scram on a second DUI. I just don't have the benefit, obviously, of knowing that. So the only thing I can go on is what I'm reading in the report. And sorry, I'm just getting Zoom started at the same time. I apologize. And what I can tell the court from the report that affects my request and has me leaning towards requesting that this court implement scram, which is a higher level of monitoring, is statements made at the scene, officers' indications that there were statements like, I'm the guy who bought your department Christmas dinner, so I'm not doing any tests. He very obstinate at the scene with officers, making a lot of comments about why he should not be arrested, why they should just let him go. So I do think that scram is appropriate in this case.
I would personally if I like to be. Are you done?
I'm done.
Okay.
You go ahead, Mr. Harlan.
Didn't mean to interrupt. When we look at the declaration of probable cause, and that's all we're dealing with here. There's common signs of DUI and somebody being grossly intoxicated. One of those signs is obviously that we always hear about is slurred speech, bloodshot, watery eyes, poor coordination, poor manual dexterity. Giving somebody a credit card instead of an insurance card, not being able to find their registration or proof of insurance. That's not the case here. None of that's the case here. You read the probable cause statement, there's not even any indication of slurred speech in the slightest. There's no indication he has poor manual dexterity. There's no indication he has any broad-based coordination issues. These are all things that a trained police officer should put in the probable cause statement. It's not there. So if it's not there, you got to presume it didn't happen.
Not when he refused. He refused all of that testing.
I didn't interrupt you.
Ms. Carmi, I'll give you a chance to respond very briefly. Go ahead, Mr. Harlan.
He has every right not to do it. He has every right not to do field sobriety tests. That doesn't mean there's not evidence of poor coordination or manual dexterity. With all that being said, I'd ask for the minimum. I mean, Mr. Olafson's been a lifelong resident of this community. He's not a flight risk. He's not a danger to this community. So I prefer and I propose the minimums in this circumstance. That's appropriate, not scram. He's not a criminal. And based upon the probable cause here, the city's not getting a conviction here. So I'd ask for the minimums in this situation.
All right,
Well-
very briefly, any response, Ms. Carmy?
Yeah, I think that that's a gross mischaracterization of the case. He, as I stated previously, there is indications in the police report that when they made contact, he was doing things like rolling his window down just a little bit, handing out a card, rolling it back up. They did notice watery eyes. And the case law tells us that we can presume that he would have failed fields because he refused them. So we don't know what his BAC level is because he refused all testing. So we have to err on the side of community safety.
Okay.
And
Right,
it sounds like, Judge, after you're done, we should probably just set this for trial from today's speedy trial.
All right, last word to you, Mr. Harlan. Anything briefly in response?
You know, somebody exercising their right not to do field sobriety tests. I don't think you can presume he would fail them based upon that. Again, there's no indication yet for broad-based coordination. The incident report, there's no indication he had slurred speech. You know, this is an officer sitting at a known bar and waiting for people to leave and pulling people over. That's what this case is all about. So again, I think that the appropriate thing here is the minimums as it relates to any type of conditions of release.
All right, thank you to both counsels. I appreciate the arguments. I did review the probable cause statement. It is fairly detailed in length. The court's considering for conditions of release whether the community is at risk as well as whether the defendant is a flight risk. I do have some community safety concerns based on what's contained in the probable cause affidavit, that it's alleged that the defendant was driving the wrong way on the roadway. There was a strong smell of alcohol from the defendant's breath, watery eyes, and the defendants made statements such as, quote, "If I blow, it's going to be over 0.18, and quote, "I've been watching golf and drinking all day." So I do have some concerns for public safety. However, we do not have any blood results. We do not have a BAC at this point in time. So I'm going to give you a chance on supervised release without a scram device. You are going to be on the administrative supervised release level with the ignition interlock device. Mr. Harlan, does your client have a vehicle, or is he looking at is he looking at a declaration instead?
No, he has a vehicle, Judge. The only thing I'd ask is, could we get a couple days to get that installed? He's actually leaving town for the weekend, coming back Monday or Sunday.
We
If I
object.
give him 10 days, is that going to be enough time?
Excuse me?
10 days instead of the 5?
That'd be great.
Any objection to the 10 days based on the travel, Ms. Carmy?
Yes, we do object and we want it done in 5.
What's the specific travel dates of your client?
He's leaving right after this hearing, comes back on Sunday,
Sunday, late afternoon.
Sunday late afternoon. So if we could do it next week, by the end of next week, be fine.
I'm gonna order the ignition interlock installed within 1 week of today. That is 7 calendar days. It must be installed by August 21st. Gives you enough time, sir, to have a couple of days after you get back to get that installed and provide proof. Must be installed by August 21st due to travel. You're going to be on administrative supervised release, sir. This is a strict compliance scenario. If we have any issues with supervised release, we will be looking at increasing that and potentially adding the scram. Ignition interlock by August 21st, administrative supervised release. Your other conditions are going to be standard DUI conditions. Violate no laws, appear at all of your mandatory court dates, including the next one that I will give you momentarily. You're going to let us know and let your attorney know if you change your address or your phone number. You are not, sir, you are not to possess or consume any alcohol or non-prescription drugs during the pendency of this case. You are not to drive without a valid license and insurance. And again, you will get that ignition interlock installed by the 21st, and you will check in, sir, with pretrial supervised release before you leave for your trip. Mr. Harlan, work with your client to get that done as soon as possible before he leaves so they can at least get his phone number.
Does he need to go down to the courthouse and check in down there? Or how does he do it relative to the battleground? I'm not sure.
There's a number on the order that should be sent to the court that they'll need to call and then set up the appointment with supervised release.
Okay, great. Thank you. Perfect.
Yep, the phone number will be on there that he can call. And then in terms of forward court dates, My next court date is October 23rd at 3 PM. If that works for the parties, that would be still within Speedy, but that's going to leave us a little bit of limited time if we're looking to set within Speedy parties' positions on October 23rd.
I have no objection.
With a waiver,
No waiver coming from this side.
then we're gonna need a different date.
Let's see if we can do. Let me just look at my calendar really quickly if I have anything before that. Give me one moment, folks.
And are we gonna contemplate setting for a Tuesday trial? Because then we could use October as the readiness date. But I don't want to set out to October unless we're setting a trial date.
I think it's probably a 1-day trial. That'd be my expectation, but
Well, I could come back and do a September date if that's better for y'all and you want to check in earlier, or if you just want to set for trial at this time, I'll ask Madam Clerks to look at the calendar for dates.
So, currently, right now, I'm gonna defer to a prosecutor. We have jury trial set for September 16th, the 23rd, and the 30th. And we can do the readiness any Thursday in September at 3 PM will accommodate, the schedule.
Do we have any October trials set yet?
We do know.
I can do any Tuesday in October, so I'll defer to defense to pick a date. If we set it for we set it for November 4th, we could keep the October 23rd as readiness.
we can do that.
All right, parties in agreement, October 23rd at 3 PM for readiness. And then November 4th, that'll be 8:30 AM for trial. Sir, those are your next two court dates. They are mandatory court dates. You do need to appear for both of those. Again, October 23rd at 3 PM, November 4th at 8:30 AM. Stay in contact with your attorney in the meantime. Mr. Harlan, anything further from your perspective?
No, nothing at this time. Thank you, Judge.
You're welcome. Ms. Carmi, anything further from your perspective?
No, Your Honor, thank you.
All right. I'll send over the paperwork here momentarily, and then, sir, stay in contact with your attorney. You're free to go. Thank you all.
Be safe, be well, sleep sweet, and much love.